Good afternoon. My name is Javier Rubinstein. I'm a partner in the International Arbitration Group at King & Spalding, based in Chicago, and I'm delighted to be participating today in this interview with Will Barboza, who serves as Brazil lead counsel for the Dow Chemical Company, to talk about the client perspective on arbitration and dispute resolution. I'm also excited to be conducting this interview along with my friend and colleague, Eduardo Damião from Matos Filho, with whom I've had the great pleasure to work and who is one of the top arbitration practitioners in Brazil and globally. Will and I have worked together on many matters in the past. He is very well positioned to give us the client perspective on arbitration and dispute resolution. Will received his law degree from the Pontificia Universidade Católica de São Paulo. He then received his LLM degree from the University of Pennsylvania Law School, as well as a business and law certificate from the Wharton School of Business. Will has worked for Dow Latin America for 10 years on a diverse range of transactional matters across the region. Will, to kick this off, can you tell us a little bit more about your role as Brazil lead counsel for Dow and the kinds of work that you get involved in on a day-to-day basis?
Thank you, Javier, and thank Edu for joining and for your kind words. So I'm currently the Brazil lead counsel. We have 7 manufacturing facilities, 5 business units operating in Brazil. So I support them and also oversight what is happening in the manufacturing from all the perspectives, considering regulatory, labor, litigation. So I've been in this role over the last 2 years. Prior than that, I had a U.S. exposure with the LLM. I also been allocated in Argentina to support some business units doing business there. So I been around for in Latin America and also in the U.S. for Dow. I'm glad to share a little bit from the client perspective, considering the arbitration and the disputes we have.
That's great. That's fantastic, Will. And I also thank Javier for his 2 kind words. Javier is one of the finest lawyers one can work with, and so it's a pleasure to be here. But Will, I think everybody, of course, we all have those conversations among arbitration counsel and litigation counsel, but of course your experience is going to be very important here. And I hear that, having practiced in Brazil and Argentina per se, and in the US, you probably have a lot to tell us about. Maybe we could start by you giving us a perspective on dispute resolution. How much of the work you are involved with involve court litigation and arbitration, and what kind of disputes you see within the Dow Group in your experience?
Sure. So I think we have kind of 2 kind of disputes. The extrajudicial ones, they're the ones that we have many, and we are always trying to discuss and align topics. So we're talking here about contracts dispute, can be about raw material supply, logistics aspects, some insurance, or even the product liability. So when we are talking about those, in my team, we face daily discussions. So we always have something that maybe we didn't elaborate great in the contract, or it is a gray zone that when we were elaborating the contract, we never assumed that situation was going to happen. And COVID, for example, during that time, we had many cases to discuss because the force majeure provisions, especially in Brazil and in Argentina, we were discussing if they were applicable or not, because COVID was something that no one saw that one coming. So we had to agree and kind of see what to do. So the force majeure, the regular provisions are going to apply, which trying to see the boundaries of the application And we have the other side, which is the litigation. We have like a large number of dockets here in Brazil, more than 1,000 cases, considering environmental, labor, civil, all kinds of disputes, and a few ones as arbitration. We don't have anyone ongoing right now, but we have a few recently. So that's the situation where we try not to get. We always try to solve the disputes as extrajudicial one, but unfortunately, sometimes we need to go to an arbitration or to a litigation, and we have like many ways to define that.
Javier, maybe before we dive into the arbitration, sorry, let me ask you something, Will, if you can share with us. I mean, I'm sure that you work closely connected with other colleagues within the Dow Group. Is Brazil the country where you have the largest number of disputes before courts? Are we the champions in disputes within the group?
Let's say that in the number itself, no, because in the US we have a larger number. However, if you consider a ratio between number of employees and disputes, Brazil is definitely a top 3, because we have like in Brazil this like the culture of the labor lawsuits. We have many contractors as all the other companies, so we see like higher numbers here than in any other region. So when you compare to the business we are doing in Mexico, for example, or in the South region, we see like half in the South region, half of our number in the South region, and in Mexico we will be seeing like 10% of the disputes. So definitely Brazil is like a champion in that number, not only in Latin America, but also globally.
And Will, with regard to disputes, do you get involved in disputes in Brazil as well as other countries in the region, or is your role, at least today, mostly focused on Brazil?
At least today, it's mostly focused in Brazil. So I am based in São Paulo, and I've been doing and handling the arbitrations and the litigations we have in Brazil. And in the past, as like when I was located in Argentina, I've been helping with the cases there. And because we are an American company, a US-based company, we end up having global disputes. So even though in Brazil, we are able to support the US with considering the global M&As we've been doing with the post-closing obligations. So we have like that kind of exposure in Brazil to these global M&As.
And you mentioned that you get involved both with arbitrations as well as court litigations. Focusing on the contractual relationships, I mean, that you get involved with, do most of the contracts that you get involved with include arbitration provisions, or is it a mix?
It is a mix. We have like in Brazil, I think that in the past 10, 20 years, the arbitration was not that well established. So many contracts end up having dispute resolutions in courts. And I noticed that over the last 10 years, the high complexity cases end up having arbitration as the dispute resolution provision. So we will notice, and there is like a clear separation. The routine contracts, those that are like more low complexity documents, we end up having a court dispute resolution. And those that are like high complexity, that are heavily regulated, we select the arbitration in order to benefit from the arbitration. That's what we try to get. So thinking about like when we are, it's not only about the money, how much we are discussing, but also the complexity. Imagine like an energy agreement, or energy agreements are like it's severely regulated in Brazil. They have like a very complex scenario. So we tend to opt for the arbitration because we envision better decisions. We envision arbitrators prepared to hear our arguments, and of course the speed of the arbitration, it's like way better in comparison with the situation in the courts.
And Will, would you say that this is a trend that you see within the whole Dow group? I mean, this, I think, wide use of arbitration, as I think all the public here that follows this channel knows, and as we've talked in the past, right? One of the most famous arbitration awards and most discussed arbitration awards in the world is the Dow Chemical Theory of Group of Companies award. So it would be interesting to see, I mean, if there are jurisdictions where I think the group is more, I think, willing to use arbitration than others, and if it's a general policy within the group.
Yes, we try to standardize globally. So we look for an arbitration as like a very efficient tool when we are talking about this high complexity, or like sensitive matters that we don't want to go and litigate those cases. So that's like globally. And in Brazil, definitely it is a trend. We notice like an increasing number, especially because we are having more places to be selected in Brazil, and the environment in Brazil is like getting more and more know-how. We notice that it's like a well-established market with like a very well-known arbitrators. So we notice that the arbitrations are based in Brazil, with the Brazilian legislation being applicable. And in the past, if you see like the contracts in the last like 10 or 15 years ago, they used to select arbitration for the contracts in Brazil, but maybe the legislation or some other set of rules applicable will not be the Brazilian one. So we noticed that the trust in the Brazilian system, it's increasing among the company, and we've been using, and we are comfortable in selecting arbitration as a dispute resolution for our very sensitive deals.
So it's interesting to hear you talk about the sort of increasing use of arbitration within Brazil. Certainly over the last 10, 15 years, we've seen a huge growth, I mean, in the arbitration market in Brazil. What about, though, the rest of Latin America? Are you seeing a similar trend in terms of growing use of arbitration, or are you seeing differences in that trend across certain jurisdictions?
We notice that they are not increasing as we have in Brazil. It's different. Like they are in from our perspective, my perspective here is like we are in a different period. So in Brazil, it's like a very well established. In Mexico, it's different, because keep in mind that we have like very close deals within the US. So the disputes are also not significant, or when it's significant, we will end up litigating in the US, not in Mexico. So that like border proximity makes different the approach we have there, considering that from a logistics perspective, it's all managed from the US. So and from the Argentina in the South region, we noticed that it's an increasing trend, but it's not well established as in Brazil. There is certain, let's say, second thoughts about using it within certain contracts. So definitely when we are talking about like those private agreements, we prefer arbitration, but we are going to disputes with like regulated, with authorities, all of that. So when we are acquiring natural gas and other disputes, we need to see what the market is asking, and sometimes they still going with the litigation rather than the arbitration.
Interesting, I think, to see this trend. Do you have a view? I mean, if you have on why you believe that in Brazil, in comparison to the other countries, in your experience and in the experience of the group, there is from what I understood, a wider acceptance of arbitration?
I think that it's because the Brazilian market end up accepting arbitration way before than the other countries in the region, and end up becoming like a market standard. So when you see like those real estate disputes, when you go to like private equity, when you go like to many markets in Brazil, they are already looking for the arbitration. So it's thinking about the templates, the contracts templates. In the past, we used to have like the dispute resolution, a courts based in São Paulo, and that used to be the standard. Nowadays, those templates has been amended to have arbitration as the initial dispute. So it's something that if we offer, and if the other part accepts, we go. And it's something that we might not discuss, because it's an arbitration, both sides accept, and we go. In the past, you need to use the litigation because some other parties, they were not accepting, so end up becoming an issue during the discussion. So it's something that we noticed, that the maturity of the market in Brazil, it's very developed, so it's accepted and easier to discuss. And when you go, it's not about like the decision itself, it's way more about the path we are going to pursue. So both parties understand that the arbitrators are going to be sophisticated individuals that will understand what we are talking about. We will be able to select like individuals that are acting in the market over the last 20, 30 years, having experience. So again, going to the energy sector, heavily regulated in Brazil, both parties agree that having like individuals that knows about that one, it's way better way to solve the dispute, rather than go to a court where we can be sitting in a court for like 3, 4, 5 years, and with a judge that might have other skills rather than knowing the energy market. So it's I think that maturity of the market end up leading us to have the arbitration really well established in Brazil. And of course, we are talking about the speed, the confidentiality, because some cases we don't want to leave the documents on a court dispute. We might not assure that we will get that lawsuit sealed. So we have a lot of challenge. So when you have those sensitive discussions, definitely we don't want to leave that one open. And that's like not only our company, we notice that the market, we don't want to have that precedent hanging out there to be discussed. We want to have like the confidentiality of the contract being respected, and we don't want to expose that one to other players, or even like to other markets.
So, I mean, it's interesting for the jurisdictions in other countries in Latin America that maybe are not as developed in terms of their use of arbitration. Is it still your preference, if you're entering into a cross-border contract, within the region, is it still your default? I mean, that you would prefer to go with arbitration, even with jurisdictions that have not accepted it or developed it in the way that Brazil has?
Yes, if we are talking about these like sensitive or like multi-millionaire agreements, for sure, but will not be the standard if we are talking about those low complexity or routinary agreements. So to solve those kind of disputes, we are good going with a court decision. But for those that are like important for our company, for sure, we tend to use arbitration more.
Do you see people, I mean, have you had an experiences recently of in any case where the opposing party push back on arbitration? I mean, or you, in your experience in the business partners that Dow has, normally it's widely accepted? And also I'd like to know if your templates all include arbitration provisions.
So we have a pushback regarding the cost. So for example, when we are negotiating an agreement, sometimes we have like a pushback because the other party will say like, we don't see that sensitivity in this agreement, or the numbers are not matching, so it doesn't make sense for us to keep an arbitration dispute here in a contract that from our perspective is not so valuable. So we see that pushback from time to time, and relates way more with cost than with the belief in the arbitration in Brazil. So it's way more those financial analysis, the cost benefit analysis, rather than any second guess about the enforceability of the awards, all of that. So we see, but in our templates, we do have the provisions with arbitration, again, for certain type of agreements. But in the routinary agreements, no, we keep going with the court, because again, those are not heavily litigated. We don't, it's way more like a safe spot to have the court, the dispute resolution there, but it's not something that we are envision needing to use, or that we see problems. But for those significant agreements for us that are like important, they have like confidential information, they have new technologies, we tend to go, because we believe that it's the best way to achieve this, the speed, the confidentiality, and the cost is still affordable considering the size of the benefits for the company.
So in your answer, so you've talked about a number of the factors that you think make arbitration more attractive than litigation, but let me focus on that. Just based on your experience in the cases that you've participated in, what have you seen as the main advantages of arbitration? So you mentioned confidentiality. You know, what are sort of the empirically? I mean, what have been the main advantages of using arbitration?
On top of those, like I can add the specialization. So we are capable of select arbitrators that really understand what we are discussing, that are they are part of the market, they are like academics in that area. So that's the benefit, because again, we're of course always when we enter in a dispute is because we want to win, and we understand that we have good aspects, but we want to be able to express our arguments, show our documents, provide our evidence to an individual that will digest and will have the skills to understand and provide a decision. So when we are talking about, oh, should we use arbitration or not, if we face a pushback and we are in that dispute, we are like, what are the chances we have to litigate that one? And on top of that, do we need someone that's really skilled, that will take time to understand what we are discussing, will take time to discuss with the parties? And so that's why we look for the arbitration, because again, when you go to the courts, we cannot find that one. And that's the main advantage we envision when we are talking about arbitration. Of course, on top of the speed, we are talking about an award that will go into the merits of the case, and will be able to provide us with answers, because most part of the time we don't we need to know it's not only a matter of who is going to win, A or B. It's way more a matter like how you interpret this contract, how you interpret this provision, and how you are going to live after that. Because we have the disputes that are going to terminate the agreement, but we also have the provisions that are only, we have the disputes about provisions to clarify something in a contract of 50 years. So we need to understand how and what are the decisions made on that topic, and how we will be moving forward, because we will keep partnering, we will keep like the relationship in some cases. So that's why the arbitration, it's a very efficient tool from our end.
Will, when you mentioned the expertise of arbitrators as a major advantage. I think being business savvy, right? I think I think that's probably sensitive to all companies and certainly to you as well. So touching upon your experience about choice of arbitrators, considering I think this interest. In your experience, because one of the criticism that is made in Brazil is that we have a small pool of arbitrators. Do you consider that to be true? In your experience, that the pool of arbitrators is still reduced? And could you tell us a little bit about how you participate in the choice of arbitrators together with outside counsel? And if you have, in your experience in Brazil, limited yourselves to always Brazilian arbitrators, or if you have had to resort to bring foreign arbitrators to work in Brazilian cases as well?
So yes, in the markets in the areas we need arbitrators, I think that we have a large number of individuals. I think that the conflict is something that end up creating some tensions, because we end up naming, and after we might have like a list of 10, 12 arbitrators that we understand that are really capable. But when we we run the conflicts, and because the tool is like increasing and we are having this market, they end up having more and more conflicts. So this is something that it's not a criticism, but it end up reducing the pool of candidates for that panel. So this is something to be considered. And going to the discussion like about how to interact. Usually, the firms, the outside counsel we engage, they proceed with like the first selection. So they end up preparing suggestions of arbitrators that we can be engaging in that dispute. And depending on the market, we also have the business folks, because they know like the well-known individuals in the market, and we look to see if they are arbitrators or not. So we end up receiving suggestions of names from our internal folks, especially when we have like those very regulated business, because people are really engaged and it's like a close market. So people end up knowing each other and they suggest, or business folks. And we never face a case where we need to bring some like foreign arbitrator. In Brazil, in our recent disputes, we were able to find arbitrators in Brazil. After the conflicts, after all of that, we were able to select Brazilian arbitrators that were like well-known in the market, skilled in the subject that we were about to discuss. So we felt that overall, the Brazilian market is well served, and we will not need to bring foreign arbitrators, considering the disputes we face. So we are talking about more contractual disputes, more economic, more dynamics of the economy. So that's kind of the disputes we end up having. So we are in those areas, we are like well served.
And do you get actively involved in the identification and selection of arbitrators, whether it's party appointed or input into the president of a tribunal?
Yes, we try to understand what are their thoughts, and also because there is something important when we are, even though the award is confidential, all of that, we also try to look for consistency among like, so we want to have like that, the same thoughts in all the cases. So as you know, we don't work only with one firm, we work with like a variety of firms, and all the companies are doing that. So it's a matter of the internal attorney to handle that one. So we need to align the speech and the arguments we are having in other disputes, arbitration or a court dispute. So we need to see, and that's why it's important for us to select an arbitrator, also to align overall the strategy of the company in Brazil, not only in that specific case. So we might have like good arbitrators, but they are not like completely aligned with some other disputes we are having. So in order to assure consistency among the decisions, that's the main role of the internal counsel in this case.
And you have a very, which is good to hear, right, Javier? Will has a very, very positive, I'd say, approach to arbitration. As you know, there are people these days criticizing, I think, in Brazil and abroad. Do you see, in your view, disadvantages in arbitration? Have you had any? I mean, of course, you can say broadly in general, but also you mentioned cost, for instance, that is a criticism sometimes coming from some of your business partners. But also in your experience in the arbitrations you guys have had in Dow in which you were involved, I mean, what were the things that you thought could have gone better, whatever it was, in the conduct of arbitration?
Perfect. So yes, the cost is something that I feel that if we could find like a middle ground to adjust the arbitration into those like not so high complexity disputes, would be something that will increase the usage of the arbitration. And the second, and this is end up being like the situation that the parties agree on having like naming one individual to it's not an arbitration itself, but the parties agree on naming someone else, a third party that will solve the dispute, working as an arbitrator, but not as a panel with like all that one installed. So it's something that we are starting to see in the market to adjust the cost. But from my perspective, what it's a bad experience with the arbitration is like significant delays. So when we notice that the arbitration is taking longer than expected, and I would say longer than expected because I know that some are expected to be like 12, 24, 36 months. I'm not saying that, oh, an arbitration, a very complex arbitration should be resolved in 12 months, because this is not reasonable. So let's say extended delays when we are having problems with agendas, when we are having like extended periods. So this is something that end up creating a bad experience, and not only from an internal perspective as like the in-house counsel, but also in the business. Because imagine that my internal clients, they do have an expectation when we are accepting the cost of an arbitration, and they are expecting something tailor-made, something specialized that will go into the merits of the dispute, and they are expecting something faster. Because in Brazil, it's well known that the courts takes way more than they should. So I think that's the criticism I have when we start to experience delays and the postpone on the decisions, and something that it's something that creates a certain excitation on the use of the arbitration. Because again, the expectation, it should go fast. If it's not going fast, why it is not going? It's something unexpected because in the merits of the case, and we need to respect, or it's because of the agendas, it's because of some timelines that are not well aligned. So I think this is something that, of course, it's in the hands of the arbitrators and the parties to agree on a timeline, but it's something that sometimes create an hesitation in the usage in the next cases. So creates like a bad precedent for the next time we're going to discuss.
So you've talked a lot about speed, I mean, as a key driver of cost. I'm curious, many institutions now over the last 5-10 years have started to offer expedited arbitration for certain types of disputes. I'm curious whether you've had any experience with expedited arbitration and whether that's been positive or negative.
We didn't have any of those, but we are looking for and seeing the point there is like how to also make the other party agree into that and that to use that specifically too. So this is something that unfortunately we didn't have the chance to use, but we are looking forward and trying to find ways on increase the use, because definitely it's important for us.
And on the issue of cost, I'm curious, we know that arbitration is, as Edu mentioned, is criticized in part because it is not as inexpensive as it used to be. But I'm curious, in Brazil, do you still consider arbitration generally to be less expensive than litigation in the courts? How do you see that?
Not anymore. From a company perspective, we see that the costs are increasing, and I'm not saying that they are going to match. So when we are looking for only the numbers, definitely we saw the numbers increasing, but also we have inflation, we have other factors that should be built in order to discuss this like price situation that in Brazil we see more inflation than in the US, definitely. So this is something that we also keep in mind when discussing. But yes, overall we see the numbers increasing, but I think that it's also the part of the discussion that it's about the cost benefit of as the point is, if it's increasing the cost, if it's but it's still showing results, still providing us with well-based awards, if it's still providing us with like fast speed, all of that, I think that the companies will still prefer to use. The problem is that when we keep increasing the cost, but we don't offer the benefits on the other hand. So it's way more, when we are doing at least internally, that analysis is way more about this cost benefit rather than the cost by itself, because we know that a lot of factors are building to that one, and we need to be mindful about it.
And Will, have you faced at all cases where I mean, your experience in the outcome of the arbitrations, and you don't of course have to give any specifics, have you been seeing the awards being complied I mean spontaneously? Have you had post award disputes in courts? What's your experience with after the arbitration is over, full compliance with the award, or negotiation, or even court litigation following an unfavorable arbitration award?
Yes, so we have like all the scenarios. So we already have arbitrations where we have like we comply and we move forward with our lives and we adjust to what has been awarded. We also have like some court disputes about it. So and we notice that those are like when it's more common when there's not going to be a ongoing relationship. So when we notice that the relationship is going to be end in that contract, the people tend to extend and try to find more arguments. So we notice it's not about it's not a criticism on the arbitration if the award was not well based. It's way more on the other part, looking for more arguments in order to postpone something that it's going to happen. So unfortunately, we faced both when people were not like following what has been agreed before, and also when we both agreed in favorable and unfavorable decisions. So we faced both and we move forward respecting what has been decided. So, but something that we notice in the not so good experiences is that the courts in Brazil, they are very respectful on the arbitration. So they respect the awards, and they just limit their decisions to follow what has been agreed in the contract. So they not even enter into the merits. They just say the parties agreed on arbitration dispute. The arbitration disputes followed all the procedures. So if it's fully in compliance, there is nothing I can add here. So they defer to the arbitration, which is very good to keep the faith in the arbitration in Brazil.
Going back to the question of cost and speed, I'm interested in getting your perspective on the use of discovery in arbitration. Is that something that you see as positive or negative, and have you seen any trends in terms of the use of arbitration or discovery in arbitration in Brazil?
Discovery, it's well established in the arbitration, and I think that make us feel comfortable because it's a little bit different than it's more aligned with the discovery in the US and all those periods than what we have in Brazil. So for us, it's good. It's positive because it's like the moment that we will be able to provide all the evidence, having the contractual opinions to be provided, and the witnesses. So from my end, I understand that it's very positive in a way that it's organized. It will not be used to postpone the process, and we'll be able like to limit and put some boundaries. So like within this time frame, you'll be able to provide all, and we'll move forward. Why we noticed that in the Brazil, in the courts, we end up having like not a defined a discovery period, which end up extending the timeline for the decision. So based on that, it's a very positive interaction, and I see with good eyes the discovery in Brazil.
And I think this is a trend. It's a very good question because, in the past, there was, I think, an imbalance, we thought, because Brazilian parties were not used to discovery, while of course US parties, for instance, are very used to that system. So maybe are more organized in terms of documents and organization and all that. Of course, you are part of an international group, a large multinational company, and I'm sure you guys have all the proceedings and all the trainings in order how to deal with document retention and all of that. But I don't know, have you seen problems with some of your counterparties in cases where there was the need to produce documents in any of the cases you have been involved with?
I think that it's like overall it's different. So when we notice that you are discussing with a Brazilian party that are used to litigate in Brazil, as you said, it's something that they are not so used to. So end up creating more tension because it's we in Brazil are not so used to having like a defined window where you can provide all and move forward. So here we always have like those like fact after the fact, and end up creating that uncertainty and delay the process. So we notice that it's hard to, when we are negotiating the periods and the timeline, in order to have the discovery and limit that one. So people always look for like an extended period of discovery because they always want to provide something else. Even though they don't know what yet, they want to have the time to look for something. So it's a challenge, but that overall, the parties we were litigating or arbitrating against, they were like also like sophisticated parties. So they tend to respect more and they understand it too. So I think that this is something that we don't face because we select the arbitration for those high complexity agreements. If we were selecting for as a standard, as a default, potentially we would be seen because we would be litigating against parties that has never litigated before and would be facing this kind of challenge.
Will, you mentioned before that Dow enters into contracts with government entities or both, whether at the state or federal level. I'm curious as to how much use you've had or experience you've had with arbitration involving government entities.
Unfortunately, we don't have. So the governments in all those government contracts, they still using most part, at least those that I saw that I worked on, they still selecting court dispute, and I think that this is not a wise decision from the government perspective, because if we were those contracts tend to be like significant, they tend to be sensitive, they tend to be very complex, and they would benefit from that. So they end up creating a second problem, that they are putting more pressure on the courts, and rather than lift that pressure, allowing an arbitrators skilled in that topic to decide about the situation, they end up getting those like very complex scenarios on very regulated agreements and bring those to a court, where a judge not only will have one more case on top of the million cases they have, and they will have one very complex case, because when we see the government contracts, they tend to be complex, they tend to be regulated, they tend to be very unique on a way. So we are not talking about standard agreements. So definitely the government should look with different eyes and start to use arbitration. Of course, they might be doing, but in my experience, I never saw an agreement with the government that elects an arbitration.
It's interesting. You just to mention, it's there has been a trend recently in Brazil, I'd say over the past years. I think in very large agreements, concessions mainly, where public entities have been using arbitration, and they are actually happy because there are many news, at least because many of those cases become public, where the administration is winning in many levels. So that has been a big incentive for the administration to use arbitration. But let me, to the extent you can review, Will. You said that you guys have templates and you take the proactive approach to propose arbitration in the agreements that you mentioned that you believe it's worth having arbitration. Do the group or you have a preferred arbitration institution? Do you give a choice to your business parties? I mean, how about the choice of the arbitral institution?
We don't have like the preference for like one institution or another. So this is something that we end up having. We take into consideration the precedent, so the recent ones that we've been litigating, how they behave, were they like good or not, they were diligent. That's what we take into consideration. From our end, we take way more into consideration the choice of law. So that one is like crucial for us. And you will notice that we have like the Brazilian, when we are having the contract being enforced in Brazil with the Brazilian parties. So that's our choice of law. And in the US, we notice we have like way more Delaware or the Michigan law, because where we are like our principal, a place of business, and where we are incorporated. So we take into consideration way more the choice of law to have something that we are more used. And again, it's because we're knowledgeable about, and it's easier to draft the contracts when we are knowledgeable about the choice of law. So that's why we tend to pay way more attention in that item rather than the institution itself.
What about the seat of arbitration, and maybe looking separately at Brazilian disputes versus cross-border disputes? For Brazil disputes, do you have any particular preference as to the seat of the arbitration?
Yes, São Paulo usually, because we have like our Latin America headquarter, and it's considering the seat of arbitration is like we take into consideration where most part of the witness or the involved individuals are based, and usually they are in São Paulo. So that's why. So in Brazil, São Paulo, like no brain choice, we go with that. And when we're talking in the US, we need to see where it's if it's like a manufacturing facility agreement. We need to see where is the manufacturing seating and how is the choice of law there. So then it's as we have like a large number of folks in the US, we end up having to look specifically for the matters of that contract itself. Might be Delaware, might be Texas, might be Michigan, but definitely for the contract or New York. But in São Paulo, in Brazil, it's definitely São Paulo because our headquarters here and most part of our folks are based in São Paulo.
And for disputes,
and Will, I think there is a.
I'm sorry. Go ahead, Edu.
No, go ahead, Javier.
I was just curious, when you enter into contracts with other jurisdictions in South America, do you still tend to prefer Sao Paulo as the seat, or are there other cities or jurisdictions where you also would be comfortable having the seat?
There, we are comfortable if we are like having the parties and everything being executed out of Brazil. We would be comfortable. So taking into consideration Colombia, if we are having the contracts among Colombian parties in being executed in Colombia, we are comfortable in having there. But if we are having for example, vessel discussions where the shipments are serving all over Latin America, we take into consideration where most part of the service is going to be provided. And that one is usually Brazil. So that's why I end up centralizing in São Paulo.
Will, I think there is, of course, a question that we always ask ourselves, right? And it's great to have you here to be able to answer to that. I mean, how do you, I think, decide how to allocate cases to outside counsel when you're thinking about arbitration counsel? I mean, what's the drive? I mean, from a panel, from previous experiences, do you rotate? You don't need to name. Have you had good experiences, bad experiences? I think this, you obviously are a very active in-house counsel. So I imagine that you work very closely with your outside counsel. So, I mean, if you could give us an overview of the nice to have and must have of the people who you like to work with, it would be great I think for us and for everybody here.
Yes. So considering this, so the most important is the relationship of the firm with the company. So not only looking to the arbitration, but also the knowledge of the firm and how strained are the relationship with Dow. So when you look, we have like preferred firms that work with us for many years. So we have like a pool, and we are rotating among those firms. So when we are having an arbitration, I look to the portfolio and something that it's important. For example, if it is a contract that we've been discussing over 2 years, and the firm end up engaging while we were like drafting that agreement, we end up engaging several partners from different areas. I tend to go with that firm for that dispute resolution because they already have the knowledge. Of course, if the partners is still there. So I look the reputation of the arbitration team. That's the second level. But the main drive there, it's going to be, they already know that contract. They were engaged in the discussions. They have part of the evidence with them. So let's use this firm because they are knowledgeable in that area and they will be able to bring like good witnesses and we'll be able to make a good case here. The second part, when we are not having that one, or if the firm that helped us, they are not working with us anymore. So we take into consideration, then the first topic is the reputation of the firm into that field. Of course, I prefer to use those that we already have an established relationship. But if none of those firms are skilled enough to that type of dispute, we will look into the market, because for us, it's, again, we are talking about a complex dispute and we want to have the best attorneys in the field. So we look for that one. And when we talk about reputation, of course, we have the rankings and all of that, but we also look for the places and or benchmarks. So we are talking about the associations. We are more active. So the Chemical Association, we are part of the Association of the American Companies Doing Business in Brazil. So we leverage in those areas to talk with our peers there, in having some feedbacks and select. So talking about those two, first of all, if there is a case that it's so connected that is a natural decision. If not, we look that one in different forums to hear the feedbacks and take that one. And also we look for the firm's track record. And when we're talking about track record here, and this is something important, and because I hear in the market, we're not only talking about if the firm won the case. Of course, winning cases is very important, but it's also how the whole relationship from the beginning, when we assigned the case, up to the end, how that one worked. How they were showing interest into the discussions, how they were trying to understand the market dynamics, how they were trying to understand the challenge of the company itself. If they are not working with us for many years, as a large company, do have a lot of complexities to be absorbed. So we take into consideration all of that, and also some looks silly, but some back office perspective. So how partnering they are with us, so how efficient they are on doing the administrative work as well, because we need to take into consideration the whole relationship and that firm track record on all the perspectives. So we look for not only for the results of the case, but also the path we follow in order to get there. So this is kind of like, in a nutshell, what we look, considering that we have the disputes, and considering that we have in Brazil, we have a large number of firms that are like well-known. So we try to, the reputation in the market, it's amazing and great that they keep high levels, but we have a high-level market in Brazil. So then we need to look for those differentiation factors. So that's why we look for this long-term relationship. That's why we look in other areas, how they behave, how they supported us, how they have their reputation in the market with our peers, with the companies that are doing the same job as we are doing. So that's why we try to share that one, not only looking for the one case.
Well, and once you've made the selection of counsel for an arbitration, how do you see the relationship between the external counsel and the in-house team? In terms of the management of the case, and how do you see the role of in-house counsel once the case gets going?
I think that it's we are very active here. So from my perspective, we partner with the firm. So we will be there like in the interviews. We will be there selecting evidence. So we want to be there present and partnering with the firm during the whole process in order to assure that we are sharing all the internal knowledge, and we are able also, because there are like the discussions with the firm, we need to engage in discussions with our internal employees or the Dow employees that are not from legal. So we are also there to give comfort to our employees, that they have their internal counsel supporting them, because sometimes, like on a deposition is not the most comfortable situation ever. So having someone that they are used to see that they are partnering in multiple deals makes them to feel comfortable and end up making them to perform better. So we also need to know when our presence there is going to show good results, and if our presence is going to end up limiting the capacity of the firm. I also look for those cases, and then I am not that present in that moment. So I allow the firm to talk directly with them to see if they can extract better results. So it's there is no formula. We need to see case by case, and it's not only the case, it's individual per individual that we are analyzing and interacting. So we need to see when we intervene more, when we intervene less, but it's a very close relationship. So it's something that we need to talk daily with the firm when we are in there, when we are within an arbitration, because it's a sensitive topic for the company, and we need to assure that we are leveling the knowledge and we are sharing as much as we can.
That's great. I think we are close to the hour, but maybe Edu, do you any final question on your end?
Yeah, just one, Will, if you can. What would be like an advice I think you'd give to a firm that work with you? Something that you'd say, this is something that I've seen and I like, and if you can say something that you don't like in the approach that firms take sometimes to clients or to you on things that you might have seen.
Sure. Knowledge about what we are doing. So, and I respect that the firms, they have multiple type of clients and they have different products. But I think that when we are talking with a firm and they show knowledge, not only about what Dow it's doing, but also about the chemical market by itself. So it's something that provides us with comfort, because it's company that it's trying to identify what's going in the market. They are keeping updated with our scenarios, and makes the discussion smoother, because again, when we are bringing the technical guys to the table to have a discussion, they are like PhDs, and they are in a level that it's, for the folks that talk with them daily, it's hard to follow. If we engage with a firm that it's not even knowledgeable about the chemical market, they will take like weeks to talk the same language. And after that, they will take weeks to provide results to the company. So when we notice that the firms are like, for example, having chemical groups, they have like a group that it's working closely, because again, it's a large market, a lot of dynamics there, so demand a lot of attention. So that's something that we feel and we value, that we feel valuable and we like in the interaction. And what we internally, what we don't like usually is that rotation. So when we start to identify that in a team, you talk 1 week with an attorney, the next week is with a different attorney, and the following week with a third attorney. This is something that end up creating some questions. So that raise some questions internally, because and then you're like, are they interacting? Are they aligned on that one? So they are all level on the same knowledge, or no, the other person left the company. We have like a disruption here, and then we need to fill in them again. So this is something that we usually don't appreciate. And the second part that as I mentioned, in the partnering with the firms, and I think that it's trending among the companies, is like all these like back office information. So when we are talking about reports, admin work, all of that, when we partner with the firm and we deliver higher results in that one, this is something valuable because all the companies, not only Dow, the multinational companies are integrated. So when we are asking something here, it's because globally we need to report. It might sound simple, but if the firm is precisely providing what we need, this is key for the relationship. So when we notice the attention on those aspects, it's amazing. And when you notice that this is like, hey, this is not the core. We are here to litigate something. We're not here to provide you a report. This is something that also end up creating some like not motivate us to work with the firm.
That's very interesting, Will. Thanks for being candid and I think going to direct to the points on that. I think Javier, on my end, that was I think my last question. Before I think passing the floor to you, let me I think on our behalf thank you very much, Will, for taking the time to be here. As I said before, I think many times, lawyers are talking among lawyers about arbitration, and nothing is more valuable than I think listening to the client. You are the end user. You have the pressure from the business units within the company as well. Even if you are a lawyer, you are closer to what the client wants, and certainly the client doesn't want paperwork. The client doesn't work nice words in a paper. I think the client wants normally efficiency. Litigation, I always say, it's very hard to sell because nobody wants to be in a litigation, even if it's inevitable. So I think it's very good that you can share, I think, with all the audience here, and it's great as you see this is a group of a series that is dedicated to the client perspective in arbitration. So thank you very much for sharing that with all of us. I'm sure everybody will learn a lot from your, I think, wise words, and looking forward to seeing you again. Thank you very much. And Javier, back to you.
Edu, I think you've said it better than I could, and really, Will, my sincere thanks as well. I think you've done an excellent job of providing us with the insight on the in-house client perspective on arbitration. And as Edu said, I think it's very important for arbitration practitioners to understand the needs and the preferences of the client as it relates to arbitration, in order to make sure that the process ultimately will meet the expectations of the parties. And I think that is essential. And so thank you both for your time. It's been a pleasure to be with you both, and we'll be in touch.
Thank you so much for the opportunity, and I truly appreciate the time sharing the thoughts and discussing with you. It's definitely worth the time, and I appreciate the chance to talk with with two skilled attorneys that I enjoy to talk with.